All right, so today is November the 1st. I want to thank everybody for being here again. And this, I believe, is our fifth week. So we are going to talk today about the politics and players of CPS and learning who does what and how they are connected. So if you heard my live where I was talking about this training coming up, I said, well, if you have been through this process, it's likely that you have a bit of an understanding this now. But when you prepare to be an advocate for others, this is something they have to know. So one of the reasons I'm doing these trainings is so that you don't have to explain every nit, tuck, and detail, and you can direct them to some of these videos directly. So if you have somebody new, they're like, I don't even know what's going on. I walked in the courtroom. I don't even know who all these people are. And, after being an attorney for 30 years, there were often times when I walked in the courtroom and there would be a whole courtroom full of people. And when you're an attorney and you're doing it over and over and over and over, you don't even realize that your poor client who's never been in that setting doesn't even understand what's going on, who can talk, who can't talk. So when I was
Mhm.
preparing some of the trainings, I thought about doing this one, which is basically just kind of going through the who's who and who is there. Also, as a reminder for the first 4 trainings that we have done, that somebody I need to mute here. I'm gonna mute somebody. So for the first 4 trainings that we have done, they are now up on a specific YouTube channel that is just for the trainings. I'm also uploading the audios to Spotify, so you can have just the audio if you just want to listen to it sometime and not be distracted by video. I know sometimes I like to do that. I've also uploaded a PDF of the slides and a quiz. I don't have last week's quiz done. It does take me a minute to do the quiz in addition, so I'm trying to catch up on those. I try to make them fairly easy, but it does make you interact by responding and actually reading the questions and answers. So, it's an open book test. You can go back and look at the slides. You can do whatever you want, but it does make you be interactive and makes you select choices. And once in a while, you'll see I just put a choice in there that you do have to think just a moment about. It was very important the last 2 weeks, the witnesses and the authentication of records. All right, so I don't see anybody else who is trying to jump in. So we are going to go ahead and get started. Oops, sorry. All right, so I call CPS litigation the trap. So being in the trap with the enemy, and the premise is there is nothing comfortable or familiar when dealing with child protective services. And the fact that the agency has the word services in its name is deceptive. Never, never, never let down your guard. Ever, ever, ever. And so many families reach out for help, right? I just had another family contact me this past week. They had reached out for help because they believed one of their children had been sexually assaulted by another child, and they end up taking their kids away from them. So, and that had to do with secret interviews, et cetera. But as if you've been through it, you already know this, as you deal with anybody's an advocate, one of the first things you have to just let them know is there's nothing about that that's going to be comfortable or familiar or logical, right? Or even something that you feel like you can logically respond to. It is a deep, deep dark hole. From the very beginning, parents are going to feel lost. They have to figure out the process, the people, the relationships, and they have to decode the language. We're going to do one particular training on just decoding the language, and that'll have to do with the acronyms and some of the legal terms that keep coming up, adjudication and disposition, that people don't even know where they are. So just the entry and this picture is so fitting for what happens, as it really just feels like a hole that you're being sucked into. So who are these people? So the parent's going to be dealing with people you never even knew existed. You're you're going to be dealing with people who had jobs you never knew existed, right? Like, I didn't even know people did this for a living by the time you get involved in these situations. There are administrative people, which are the agency people, and they all have different roles. There are the legal people and the court people, they all have different roles. And then the service providers, of course, who are the people who are supposed to be helping the parent manage what they need and all of those different roles. All right, so who's on first? I thought this was a very good sort of illustration. Being as old as I am, I remember things like this. So, there's an old comedian team called the Abbott and Lou Costello, and there's a whole skit on who's on first. And Abbott says yes, and Costello says, I mean the fellow's name. Abbott says, who? And he says, the guy on first. Abbott says, who? Costello says, the first baseman. Abbott says, who? Costello says, the guy playing. And Abbott said, who's on first? And the whole thing is about the name of the person who was on first was who. So, but it's just this comic thing that you feel like, and parents sometimes feel like, even when I talk to parents now, I'm like, who's the guardian ad litem? And they're like, what's a guardian ad litem? Who's the caseworker? Who's the investigator? Who's your state legislator? I mean, learning this whole new population of people that they have to deal with, right? It's like on a day-to-day basis in your daily life, going to the grocery store or getting the kids from school or, parent teacher meetings, you're kind of cast into once in a while a little bit a different environment, but you can assimilate what's going on pretty quickly. Just take a school meeting, for instance, when you go to a school to have a meeting about a child, an educational meeting. I mean, going in there ahead of time, like what kind of people are going to be there, and you kind of know who's going to be, how decisions are made, what kind of topics are going to be, but you don't know any of that in child welfare. And sadly, the parent knows nothing, and everybody around them knows everything, and they don't want to tell them. They don't even want to talk about it. All right, so finding out who's on first in your case. What you really want to know is who has decision-making power, what decisions they're allowed to make, are different people giving different authority at different times, and how can I best affect that outcome of those decisions? This is a very good primer, right? So as somebody is stepping into their case and you're interviewing them and they have just gotten involved, you want to kind of figure out, or you want them to start in their minds. You want them to start calculating who are these people and how can they help me? Like what role are they going to play? How am I going to deal with these people? And if you've been involved, you understand how mixed up this is. And this particular question here, are different people given different authority at different times? Absolutely, yes, right? So the guardian ad litem has certain authority, the CASA worker, the case manager, etc. So so understanding that has to be part of the process is a big step for the parent who's involved. So the answer is yes, there is more than one decision maker, more than one decision to make, multiple people who want to put their two pennies into the equation. And you, meaning the parent, is going to feel like the lowest person on the totem pole. All right. Now, and remember, that parent, that lowest person in the totem pole in this whole process, is the one with the most information. They're the one with the most information about what really is at issue. And this is becoming very frustrating for me. I went recently through a foster care review board meeting with a parent, and they put it on Zoom. Nobody shows their face. You don't even know who's there. I think they're afraid to show their face because they knew she recorded. The caseworker comes on and blah, 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 blah. And then the parent is very patient, very quiet, sits there patiently. And then the caseworker says, okay, well, that's it. We need to adjourn. And the parent says, I want to talk. And they're like, we only have 15 minutes for this meeting, so you can't talk. So remembering the parent's the one with the most information. We have to make a place for their voices to be heard in the process. Last week, I don't know if we talked about during the training or afterward, but putting together a mother's court report, a parent's statement of facts, a parent's response to the foster care review board meeting. There's going to have to be this written kind of response so that we're properly developing this record so they cannot ignore the facts. So who are the agency players? So you have the investigator, who is really the first one who knocks on the door. You have an investigative team, which means that the investigator has a supervisor, and then if they heighten it to what's called a CPIT team, a CPIT, that it usually includes law enforcement or a district attorney. You have the caseworkers. So when the investigator has essentially closed their case, which in Tennessee, they were supposed to do it in 30 days. They've now extended it to 60 days. But at some point, the investigator is out of it, and the caseworker is the person who is managing the case. But the investigator ends up, as we talked about last week, often being the key witness. You have the foster care worker, again, part of the agency. You have the education specialist, the facilitator, and supervisors. When you go into a family planning meeting, you are surrounded by all of these people. So a parent goes in there, and again, the parent is the one with the most information. The parent is the one with the information about her children and what the needs of the family are. And yet you have all these individual separate people, all separate, all have their little bucket list of what they want to do. And they're very, very pigeonholed. Right? They want to, the foster care worker doesn't want to have anything to do with the education specialty, which again is it makes it a very fragmented system. In court, so in court, you have a whole different set of players. Very intimidating environment, number one, just the structure of it, the benches, the robes, when you can speak, when you can't speak. You have always have a dude over in the corner, typically has a badge on. I don't know if he has a badge. He usually has handcuffs jingling from his belt. And then you have a clerk who's sitting there who, most people they don't even know what she's doing. And then sometimes a court reporter, and then tables and podiums. It's just a very, very, very uncomfortable environment. So you have the CPS attorney, are the DCS, the agency attorney. You have a guardian ad litem. The parents have attorneys. There is either sometimes a preference attorney or an attorney ad litem. You have the judge, sometimes a probation officer, and then you have the court officers and court clerks and deputies. I think we've got a slide to come back and talk about those. If not, I'm going to come back to this slide and talk about number 4 in particular. All right, then you have the providers. So the providers, it sounds like it should be some kind of a scary movie, right? Like the givers or whatever. But the providers are all these people now who that agency has engaged to be able to fill this gap of what do we need to do to have a safe environment for the child. So you have trainers, anger management, parenting, home services, budgeting, visitation supervisors, psychologists and therapists, forensic interviewers, foster parents, CASA workers. And there you go. So interestingly, these trainers, the trainers themselves are frequently not necessarily specialized in anything. The contractors that are providing these trainings are putting together very very basic training packages, but the people teaching them, most of them are online now. They're doing, if there's any personal engagement at all, it's very if there's any personal engagement, they're not like they're licensed, they're educated people. The visitation supervisors are also kind of this vague, they're not licensed, some are therapeutic supervisors, some are just supervisors. They're supposed to be taking notes. Parents need to be able to get those notes. So you can see already we have listed about 18 people who are just totally unknown to the parents. Totally unknown. They don't know what they do, when they start, when they stop, who pays for them, how you schedule them, or anything. So just imagine just imagine, it's so hard if you've been through it, or as an attorney, if you've been through it over and over and over, because as an attorney doesn't really have time to deal with these people. Okay, you can't even deal with them. So, but your parent has to. So they've got to get themselves in this mental state right away that they're going to have these strange people. I have said to parents, that visitation supervisor needs to be your new best friend. Ask her about her favorite recipe for cornbread or something. Try to have some type of engagement with them. Right, so how do they fit together? So the most important thing to know is the relationship between the judges and the other court players. The judges appoint parent attorneys and guardian ad litems. The judges hires the magistrates, the court officers, the clerk, anyone else working in the courtroom settings. So tough decisions may be influenced by relationships that go beyond your case. That's just the way it is. Particularly guardian ad litems and court-appointed attorneys. I mean, I don't even know, this is one that you just can't even, it's so hard to get to the bottom of it, but you cannot ignore it. I mean, I have gone so far as doing an open records request for all of the payments from a particular court to a particular attorney. And I identified like all the attorneys who were getting appointed and how much they were getting paid out of the system. And then particularly in not so much like the major metropolitan areas, because there's just so much going on and so much has to be balanced. But some of the secondary markets and the smaller communities, especially smaller communities, you're going to see these people playing the same roles over and over and over. And I'll just tell you, years and years and years ago, I was a district attorney in Davidson County, and I worked with the same general sessions judges over and over and over and over. And I was doing minor misdemeanors. I was doing thefts and DUIs and simple possession, just kind of, nonsense stuff. But, those judges and I cannot deny that those judges and I had a relationship. And so those judges understood what to expect from me when I went in the courtroom. I could sort of understand what I expected from them. I could walk in the back room. I mean, I had done it. I mean, again, it's 25 years ago. I don't think they can do anything to me now on it. But I mean, I've gone in the back room and told a judge, look, this is going to be a really difficult case. Just be really patient with it. Not really like giving him that, an answer or communicating with him about the facts of the case, but particularly where I had a case such as a domestic violence case or a family violence case where I knew I had a very troubled victim. So you cannot ignore the fact that there is some other relationship besides your case. Sometimes they have, I don't want to say parties, but they have other events and stuff that they attend. So there is something going on besides just what's going on in that courtroom setting. Always important to remember. All right, now, are there competing interests in the outcome of the case? Of course there are. This is a horrid question to consider, but yes, you must answer that. There are competing interests. So family justice and restoration versus better statistics for the agency in court. On the last few trips when I've gone to Washington, D.C., and we have meetings with young aides, and we try to keep our meetings in about 30 minutes. We always take a couple people with personal experiences. I sort of give an opening and a background. But one of the things that I have really got to the point where I talk to these young aides about is I am like, look, when you have 5 attorneys on a case, what do you think all of those attorneys want to do? Those attorneys have one goal in mind, and that is to win. They just want to win, okay? Every attorney wants to win, okay? They don't care what the outcome is as long as they win. And so that's why we're working towards family advocacy. That's why we're working so hard to try to get our Advocates for Families Act passed as well. So family justice and restoration is always in a competing environment to get statistics so they can do what? Of course, get more money. I love this picture. This is like, I thought that picture was so good. Attorneys are afraid to fight. There are times that attorneys are just afraid to fight. They're court-appointed attorneys. They're appointed by the judge. Sometimes these attorneys, their sole source of income is their court appointments. They have limited billing. They can only bill so much. I think in Tennessee, it's like $2,500 for very, very complex cases. Retained attorneys often lack the specialized training. They feel helpless against CPS, and the delays cost the parents an exorbitant amount of money. So let's go back and talk about the court-appointed attorneys for a minute. So there are attorneys that just take court appointments. It's just the truth. It's the way they work. They don't have to have an office. They can operate out of the trunk of their car. They have a mail slot in the clerk's office where any of their, they can put pleadings, they can accept pleadings, they can communicate, pass information there. They are on a list with the judge, and they are going to get appointment after appointment. There are some that even just show up, right? Like if they know, and some of the major courts have attorneys do that. I know, in Davidson County, they have a roster, and these 4 attorneys are to appear in court on, the first Tuesday of the month. Then these appear on the second Tuesday, whatever. So whenever they're having these preliminary hearing dates, they have people available right there to be appointed and talk to the attorneys. Now, this is the first time the parents have ever seen them, but remember, everybody else knows everybody else, right? So this is often their sole source of income, and they have this limited billing. Retained attorneys, so many people came to me, and I mean, of course, it's one of the reasons they wanted to get rid of me, is because I intentionally specialized in a lot of the laws, the rules, the cases, etc., the rules of evidence that would all be relevant and pertinent to CPS litigation. But a lot of them just lack the specialty training. So what kind of specialty training is there? So one of the things, for instance, is juvenile court rules. Juvenile court rules are different in Tennessee than the rules of civil procedure. The rules of evidence, they are supposed to follow the rules of evidence, except the juvenile court rules has all kinds of exceptions, like when they can do hearsay, etc. So understanding that specialized training. Also, just the statute on juvenile court and the proceedings, as well as the adoption and termination statutes. The termination statute, it's just horrible. It's horrible, hard to understand. People don't even want to look at it. So many attorneys in Tennessee will say, I'm just not even doing DCS. It's just costs too much money. They keep driving you back and forth to court. You can't get anywhere. So we really have a dearth of really qualified attorneys. Now, after saying that, I do want to say that throughout the United States, there are some great groups that are doing some great things for parents and families. I know a handful of individuals. I'm not going to give their names of those who are involved in Family Forward Project. Probably know who a few of those are. But there are also like the Bronx Defenders, who's really established a nonprofit to be able to provide these services. So hopefully our advocacy program is going to end up supporting the people who are going through this process, and then also supporting and assisting attorneys, so that more attorneys will be involved if they have a specialty organization such as advocates to be able to help manage the parent, to help organize the documents, etc. Okay. All right, so the other problem we have, of course, is we have CPS workers with an agenda. Everything that can be wrong about a job. They are low-level workers, they're overworked, they're pushed by their supervisors. Social work is not social work. They have quotas, placements, adoptions. They see the parent as the enemy to getting their job done. Oh my gosh. The attitude of social workers that work, or case managers that work with CPS, is not improving. Everybody that is finding us, that is reaching out, that is sending us information, the attitude is getting worse and worse and worse. They won't call back, or they notify people at the last minute. I just talked about a foster care review board meeting where they cut the parent off and wouldn't let them talk. I mean, they're not there for case management. They're there to handle their caseload. That's it. And get their reports done and file their reports. Sometimes, unfortunately, we have judges with an attitude, so we have very little oversight of judges. There are judicial ethics boards. They really don't do that much. Well, many attempts have been made to file ethics violations, and they somehow tend to skirt around them. I mean, I had somebody just dead to center one time on an ex parte communication, and the ethics board even told me that they had clearly there was an ethical violation in the ex parte communication, and then the next thing you know, he slipped in some type of secret deal to protect his role of where he was. Of course, they have immunity where you cannot sue them. So many people are, can I sue the judge? Can I sue the judge? I'm going to answer this question right here and now. You cannot sue the judge. The only exemption to that is if they're acting in an administrative capacity or without jurisdiction, and you probably won't make that, okay? There are very few circumstances that you can meet those requirements. Parents are silenced in and out of the courtroom, okay? So parents are silenced in the courtroom. They're not allowed to speak. I'm hearing this over and over. And, we want reports on this and we want to get the feedback because these are laws and things that we can change. Out of the courtroom, they're given gag orders. They're told they can't use social media. Even their attorneys tell them that they can't use social media. So there are gag orders that are put on parents where they can't even talk about their case. And honestly, one of the best healing or one of the best emotional the ability to emotionally process comes when you can talk about it, when you can say something about it. And you know what? You're right. You may not be, you may not talk about it in the most calm fashion sometimes, or you may not get everything exactly right. You may have messed up on some comment that you make about them, but talking about it and putting it out there and just putting it out there and seeing some likes, just some confirmation, some affirmation really is helpful to parents. What I hope to do as we move forward with the process that we're doing is that we will then be able to move to doing some kind of a group, a chat thing on Zoom. And then the other one is where we will keep private. We will not record that. But then otherwise, we are going to do sort of a panel discussion on a few of these topics where we'll have about 4 or 5, maybe 6 people at the most. If we do those, you will need to, identify who you are and show your face and all that stuff, but have a discussion for instance, about parents being silenced or one particular topic. The review process on the opinions of judges, appeal is just torturous process. We have cases now where, that I have worked on that have taken 9 years to go through the appellate process. And the fact that a child has lived in this purgatory for 9 years is so absolutely destructive. It is lifetime of destruction. The judge has control over the courtroom players. And interestingly enough, with all of that being said, the judge has a lack of power over the placements and the agency has complete control. That's just the way the statute is. But then of late, I've seen a couple judges order the agency to rip a kid out of a foster home. I'm like, they just make up their rules as they go along, unfortunately, sometimes. But by law, it's the agency that's supposed to have the power over placements. Then you have children's hospitals and CAPS. So CAPS are child abuse pediatricians. This is a very interesting topic over the past 12 months that is developing, and we'll do some more on this. If you watch the Take Care of Maya movie or trial, you can see how CAPS, child abuse pediatricians, play into this. Also, most recently in Texas, the Roberson execution was stayed because of child pediatricians who came in and neurologists who talked about a man who was wrongfully convicted many, many years ago due to basically a child abuse pediatrician. Now, child abuse pediatrician wasn't technically certified at that point, but it was the same kind of thing. They were giving diagnoses of abuse when they didn't have supporting medical evidence. So there is money directly from the state agencies to these children's hospitals. So there is a conflict of interest. And there is a money for care of children in foster care. So for instance, when we start learning to do some investigative tactics, you can go to look at your state checkbook. Most of the states have some type of application or interactive website at this point where you can search money. I have searched Vanderbilt. The last I saw, I think, was $4 million a year that was going to Vanderbilt. They do have child abuse pediatricians, and they do treat foster children. So they're getting a significant amount of money, but yet they're coming in, sending a doctor in to testify against parents. The CAP child abuse pediatrician was a certification that was approved in 2009. And boy, you know what? I was right there when that happened. The very first time I saw a child abuse pediatrician was about 2011, right after this certification. They're everywhere now. And I mean, my very first deposition with a CAP in about 2011 was jaw-dropping. I did too, like right in that time frame. Absolutely jaw-dropping, some of the things that they said. So on a fractured rib case, I actually asked the doctor, so you really believe that those parents like picked that baby up and crushed their ribs with their bare hands? And she said yes, when it was a fractured rib metabolic deficiency case. They're also contracted to do the death review cases where they look at the children who have died, and not necessarily in foster care, but all child deaths. They're supposed to do a death review on, which is kind of interesting. You don't really see much of the results of that, but they're also being paid for that. Oh, and I want to go back to that for just a second, actually, on Vanderbilt, when I was bringing up Vanderbilt and their interplay with the state agency, Vanderbilt Children's Hospital actually had on their website how they, not in the exact words, but basically considered themselves a partner with DCS. All right, so the money trail. Again, a lot of you already know this. Parents are not going to know this. They don't understand this money. And you would be amazed how many legislators do not understand this. If we can start getting the legislators to watch a few of these videos, and we have to pick and choose maybe which is the best one for them to look at. But understanding the money for the parent is very important, because the Title IV-E money for children in foster care is the driving force of putting children in the foster care system. The federal money flowing to the state budgets per head, per day, every day, it's a quota. We've got to keep our counts up. They're reporting, they're watching those counts every day, like the stock market, right? Like how many kids are in care today, how many are Title IV qualified. I mean, they have to be, because they depend upon that money for their budgets. There's a massive state administrative budgets, and those administrative budgets depend on the Title IV-E funds. Now, what I'm seeing more and more and more of across the states is more and more states are privatizing the case management, which is a new kind of shifting of the Title IV-E funds. We're going to see how that goes. I know Florida has completely privatized that, and Tennessee is looking to do that. I actually saw where they had a contract out to do that recently. So the funding is behind the curtain, and the parents don't even know about it. And I'll be honest, I just saw the strange activity that was going on with DCS. And one day somebody happened to mention that they needed to do certain things to get their funding, their Title IV-E funding. And I was like, that's when I like really went, oh, light went off. I'm like, okay, I really started investigating it. All right, here's an example in Tennessee. For 2022, the total budget was $1 million plus. 1,119, and I'm sorry, 1,119,500,000. So sorry for you people listening on audio. I'm sorry I messed all that up. $1 billion, okay? The state tax money was $463 million. The way it's reported, it says that the federal tax money is 192, and the other is 463 million. Okay, so we have $1 billion budget, 463 million from the taxpayers, 192 million from federal taxpayers, and 463 million from others. Okay, so where did I get those numbers? Right, if you look right here, oh, these are the expenses. All right. So I want you to look at these expenses while I have this up. All right, here is a 20 up at the top here, 20 to 21 actual. And then the recommended 22 to 23. All right, so you see here in salaries, we go from 166 million to 204 million. All right, now that is about what, 25%, 20%? That's about a 20% increase. And then you have, of course, some of these other things. You have longevity pay, overtime pay, benefits went up about the same amount. So their total payroll is 296 million. All right. Then you go down to grants, etc. Let me get down to what is this? Professional services. Total operation. Okay, so their total operational budget, which grants and subsidies means that those are grants that they are giving out. So my presumption would be that these grants and subsidies are primarily Title IV-B money, which is interesting the way they've got it marked there. But their total operational budget is 823 million. Now, keep in mind for Tennessee, that's about 10,000 kids in foster care. So that's just the operational budget. That doesn't include any of the foster care money. The Children's Hospitals, what I talked to you about before. So for the state of Tennessee, Vanderbilt Hospital, money paid directly from DCS increased by $1 million in 5 years. So this is the image that I get when I search the Tennessee checkbook. And let me see if I can move your little thing here so I can see the year. So that's 2015. This is 2015 over here. And this is 2020. Okay. So you see a $1 million here in the increase in a 5-year period. Oops, I think I go forward to 20. All right, so what do you do? So a parent, again, we talk about it over and over and over and over. They must make notes on everything. I want every parent to have a little spiral binder just like this. You can catch them if you check someplace that has cheap school supplies. You can buy those little binders typically at $1 a piece. They're very cheap to do. Handwritten, every page, at the top of every page. You put the date. I always put it in the top right-hand corner, the date, and then I put what it was, whether it was an event, a meeting, a phone call, and then I make my notes. Get everyone's name, first and last, who they work for, who they report to, how they are paid. Don't be afraid to ask. In every agency meeting, in every court appearance, make sure you know who's there and make sure that our parents are trained to know who's in the room. So, and ask for the best means to communicate, complain, or report when you feel there's a conflict, unresponsiveness, or disrespect. So when parents go into these, and we'll talk about as advocates going into some of these very first meetings where we are, getting a parent set up and situated, and in these first meeting, I don't know where I went on the screen here. I'll move this over. Oh, there I am. In these very first meetings, when a parent sits down and they're in this room full of people, we want them to immediately have this little notebook and start writing it down. And, we can then, now these are their special notes. They're not necessarily going to be made available to everybody, but this is for the parents. Write it down. People unfortunately anticipate that they're going to work with them, and they don't understand that they're not, and they're going to be working against them. Recording, we'll talk about this over and over and over and over, but we want audio recordings. I use one similar to this. I use an Olympus, but I do have one. Make sure it is one that you can plug in directly to a computer and download it or upload it online, someplace where we can keep it safe, in a Dropbox, in a Google Drive, someplace where we can keep these. You want to make sure you see here, I don't see the date on this one, but these Olympus have a way that you can set the date before you even start recording. You need to take a minute and learn how to do that. because it's very important when you download it. You just set the date. As long as the batteries are good, it's going to keep changing the date. So you don't have to change the date every time you start your recorder. So, but you want to upload those. They'll already have the date on them. I add a note to the file name so I know if it was a meeting, a phone call, or whatever. So they're going to record meetings, supervise visits, training, therapies, class participation. So recordings in courts are somewhat different. Some courts will restrict your use of a recording. Tennessee has a law that judicial proceedings can be recorded. They don't like it and they fight it, and the law says that attorneys can do it, but then there's a case law that says a pro se litigant can do it. They still try to block the parents from doing it, and it's so imperative. And we have to get that law changed. We have to get a law that recording can occur in every courtroom. They can record anywhere they want, and if it's not under some type of protective order, they can share it. You know, these courts are scared to death of the public learning how the courts operate. They are scared to death of that. And you know, that's why they block me and gagged Wendy and gagged these parents, because they don't want, you know, they don't want the parent talking about it, but they don't even want the parent to be able to share the real thing. Like, if you don't want a parent talking about it, then they should be able to put their whole hearing. I mean, we have court TV now, right? They should be able to put their whole hearing up on Spotify or SoundCloud or Apple iTunes, whatever they want. Somebody wants to listen to the whole thing, listen to the whole thing. People there are a lot of people who are kind of geeks about court TV, right? I mean, there are some of them that I've watched start to finish. So, but definitely parents need to record. Let me see if I talk about transcription on here. Oops, sorry about that. Okay, so what not to record. A parent should not record their conversation with their attorney unless they discuss it in advance. Now, some attorneys say it's okay with recording, so you can review the discussion, but you should not want those conversations mistakenly given to opposing parties. All right, let me talk about that a minute. So when I have clients come in and talk to me, I would often say, you are free to record what I'm going to tell you. You are free to record my discussions with you about where I think your case is, because I know it's complex. And when an attorney starts talking, they talk about, you know, different strategies, different evidence, different witnesses we may need. Okay. So you are free to record, but just be careful. You don't want our conversations to get leaked out and then have those conversations in the hands of the opposing side, right? It's like the football coach, right? Teaching his guys certain plays. You don't want the playbook released to the other side. Now, also, recordings these days can be easily transcribed with artificial intelligence. There are lots of websites in particular that I use and we'll talk about that again in more detail as we talk about recordings and preserving evidence. But we can get those transcribed, and you have to, technically, there's a few things you need to do, but they're not that complicated. All right, recording video. Recording at your home, you can record anything in your home, okay? The CPS and the police are at your home, you can record them. Or your work, you can record them. CPS in your home for inspections, you can record them. Agency meetings, they may oppose it. Court hearings, a judge probably will not permit a video recording. However, I think they should all be video recorded. And a lot of the juvenile courts are video recorded, but they control those videos and won't release them. So, you know, we can ask if the court recordings, if there are court recordings of proceedings. That sentence is a little not written very well. Ask if the court records proceedings. That's what it says. That's what I meant. Whether or not they're recording them by audio or video, and how to get a copy of those. In Williamson County, Judge Guffey wrote her own rule that says you can't have it unless you file a motion and I give you permission to get it, which is so ridiculous. And the Court of Appeals has upheld that she can have that rule. So the General Assembly has to overturn it at this point. I can't get the courts to do it. So record in your home. DCS comes into your home. video record it. Now, they'll fight that too. They'll say, I don't want to be recorded. You just say, you know, I'm sorry, you're in my home. I'm going to record it. I may need to use this as evidence. I want a complete recording of what's happening. I want to have, you know, if we have a discussion, you're going to make notes. I don't want it misinterpreted, so I'm going to recording it. I mean, we live in an age now where we can get so much evidence, and we can almost too much evidence. We can get too much stuff. It's so much better. When I did my very first civil rights case, and it was all he said, she said, nobody had a recording, and they bursted into the home, etc. So it is, so now we're able, and we should be able, but not only do you record, collecting it, labeling it, storing it is all going to be extremely important. Calendaring all events, paper or electronic, why paper is better, and how to use both. Agency meetings, agency contact, provider contacts, court hearings, contacts with attorneys and guardian ad litem. Okay, so there's a couple things here. As you see in this little picture here, this picture is a picture of just a blank calendar with the dates in it. Okay, it's just a white sheet of paper, and it has the dates in it. I would download a calendar, a month at a glance calendar, from just download the PDFs and then print them off for the clients. And I would use them myself. And I loved having these. I love having these. Now, this does not replace the little spiral notebook that we talked about before. Because, for instance, on, let's say that's August the 29th, where she's put a pink highlight around, she's just going to put in there agency contact or agency meeting or PC for phone call, PC with Stella or whatever. And then you're going to have, so that it's not too cluttered, because there's not too much information you can put in there. But then in her notebook, she's going to write down August the 29th, phone call with Stella. We talked about the anger management class. She's going to schedule it for next week. Okay. And she repeats that and she gets it written down. The reason I like these calendars is because if you have to go to court, and let's say one of the issues is whether or not the parent's staying in contact or whether or not the parent is completing classes, you have these calendars that are so easy and visual for a judge and you know, the guardian ad litem and everybody else to see at a glance. They can see, like, if your client has been calling every 5 days, or your parent has been calling every 5 days, and they just have a list of dates, it's not as impactful as holding up the calendar and showing those squares. Now, somebody wants to be really, you know, really artistic, they can color code it, right? They can use pink for visitations, they can use blue for court, whatever. However, just remember this. If they color code, very good. Amy's holding up her calendar. I see down there in the corner. I don't know if anybody else can see it. If you color code, though, keep in mind that when you go to court, you have to have color copies. So I don't always, I mean, just, you know, color coding's nice and fun, and it helps visually when you want to hold it up. But if you're going to pass it out as an exhibit, you are going to have to make color copies so everybody has the same thing in front of them. But having both things, having the calendar, the month at a glance calendar, with not a lot of fancy stuff. You know, I have to say recently, I bought this calendar. I think I got it at an office supply place. I thought it was kind of cute, but it has like flowers around the edges and all this kind of crazy stuff that's just way too fancy. So, all right, we're going to move on here. I'm on my end. I look like I might be glitching a little, so I hope we're moving okay. I know the recorded on the computer will go okay.
Connie?
Yeah.
I do have the at a glance, and I have the calendar that I keep color coded. But past those, it allows for paragraphs for each date.
Yeah.
I write the details in black and white.
Yeah. You're breaking up on me too a lot there. Sorry. Okay, so what not to put in your case notes. Okay, so don't put in your case notes things that are confidential and personal. If you use your calendar in court, the opposing party is going to be able to take a look at them. Do not put this in your case notes, any communication with your attorney. Now, if you just want to mark on your calendar, just like PC with attorney, but don't put any specific information in there. Personal notes about your kids, notes about your mental health struggles, emotions, your own trauma, and name calling. Okay. Don't put in your notes, the CPS worker's a bitch. Okay. We just don't need that. You can put a B, I guess, if you're really frustrated that day and you need to express it. But if we use those notes for a parent to rely on when they're testifying, the other side gets to see those notes. If they're using them just for their own personal information and to share with their attorney, the other side will not necessarily get to see them, but most of the time, the attorneys need something in front of them to testify to. And at some point, we'll talk specifically about trial prep and just having maybe some note cards or a timeline or something simple to help them. But you just want to be careful what you record, again, in case it gets in the hands of the enemy. Last but not least, our children's attorneys as other players. Oh, and this is where I talk about attorney ad litem's. I thought I had this in here. Last but not least, children's attorneys. So the guardian ad litem versus the preference attorney or the attorney ad litem. So the guardian ad litem is supposed to be advocating for the best interest of the child. Now, what is the best interest of the child and whose eye, right? It's all in the eye of the beholder. So it's very subjective. There are not objective standards. Those subjective standards do not include a heightened perception of the necessity of a child retaining relationships with their long-term family and their family of origin. So I have a lot of problems with that. The attorney ad litem or the preference attorney is the attorney who's supposed to be representing the child's wishes and rights. And the children have a constitutional right to family integrity. So here's a very, very important thing for attorneys and parents to understand. Let's say there are 3 children, and let's say the children are 6, 7, and 12. All right. So a guardian ad litem gets appointed for the best interest of the children. And maybe the oldest child is vocal enough to say, or any child just says, I want to go home. When can I go home? I want to see my mom. I want to go home. Can I go to my grandmother's? If at some point the parent feels like the guardian ad litem is not recognizing the child's interest and supporting the child's interest, you can request an attorney ad litem in addition to the guardian ad litem. I have done this. They give you lots of grief about it. They don't want to do it. Some judges say, well, the guardian ad litem is the best person to make a decision about that. But the guardian ad litem has an obligation to get a certain attorney for the child if the child's wishes and the guardian ad litem's opinion differ. Okay. Attorney ad litems for children have won cases for me. So if we find that these guardian ad litems are not taking into consideration the family integrity, the relationships between the families and the parents, then attorney ad litems are going to have to be participating. CASA, our court-appointed special advocates, they are volunteers. They are not required to have any certain educational background other than a high school degree. They're trained by the organization. The organization receives tax dollars. There are secret hearsay reports filed directly with the judge, and 90% of the time they support removal. I mean, I don't know what to do with them. Very rare over 30 years of working, 28 years of practicing. Very rarely did I see a CASA worker support the reunification of a child and a parent. Now, they're not licensed to do anything. They are volunteers. They are sometimes, and they may be a teacher, but they may be an insurance salesman. They have no particular background that is required of them in social services. I don't know. I've got their training book, but they're not really trained on separation anxiety, separation, long-term separation trauma, etc. All right, so children's constitutional right. In spite of support of policy experts such as Martin Guggenheim, Richard Wexler, Dorothy Roberts, Daniel Hatcher, a recognition by the Bar Association and a recognition of the Bar Association, the children's rights are sacrificed. My Family Belongs to Me is an old article, well, not super old, but an old legal white paper, a child's constitutional right to family integrity. You know, I wish more judicial officers would study the family integrity, that constitutional right, because it is, you know, and it says right here, under current law, a child's ability to assert a constitutional right to keep their families free of government intrusion is not always apparent. This is in part because of the single piece of the Supreme Court dicta has muddled an otherwise clear family integrity doctrine, and many circuits are silent on the issue. So that's a great article on that. You know, these articles are very long. I'm trying to pick and choose things out of there that might be helpful. But the children do have a family right, or a constitutional right, to family integrity. My family belongs to me. It says this. Despite the support for the existence of a child's independent right to family integrity, children rarely assert this right. As a result, children are virtually shut out of the legal proceedings that affect their families and stability, usually based on allegations against their parents, not themselves. This may be due in part to the fact that the legal landscape is not clear, but it is also likely due to the confusing role of children's advocates in civil proceedings and the fact that children in many of these proceedings have no advocate at all. If a parent fails to assert her fundamental right to her children in those proceedings, or is unable to do so because of a finding of unfitness, family integrity may never be considered, even though the implications for the child can be devastating. The Supreme Court has noticed that directing the onus of parents' misconduct against his child does not comport with the fundamental conceptions of justice. Got that? I'm going to read that again. Directing the onus of a parent's misconduct against his children does not comport with the fundamental conception of justice. Yet the court has not given this observation legal force by overtly recognizing a child's right to family integrity or clarifying its parameters. And, you know, the people who write these great esoteric white papers somehow get lost in the system, because I never hear those words come out of a courtroom or an attorney other than me. This is a great a drawing that was created out of somebody who went through a horrible experience in either Washington or Oregon. And I think you all can take a look at that and realize that it speaks volumes, right? I think I put some of this up in a video as well, but just all that frustration and how people feel all that frustration about children feeling like they're in foster jail and I want to go home, and the secret courts, there's no evidence, there's corrupt judges, they gag people, they auction children off basically, you know, to the where they're going to get the most money. It's just a very frightening experience in so many ways. It's so frightening. Ephesians 6:12 says, we wrestle not against flesh and blood, but with the principalities, against powers, against the rulers of darkness in this world, and against spiritual wickedness in high places. All right, our conclusions, and then we're going to go offline here and have a little discussion, but our conclusions, there's only one way to make it through this process, and that is never, never, never give up. Document, 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 educate yourself, prepare your case, find support or advocates, pray and persevere. All right, so I am Cynthia. Oh, Cynthia is not using Vincent Edwards, so that email is not good anymore, but my Connie.familyforward email is good. I do get a lot of emails though, so it's I'm not very difficult for me to respond to every email, but I have enjoyed giving this presentation. I hope it's giving the people in the class a better understanding. I think the people in this current class have had some type of experience, so they have some understanding of it already. But as we reach out and engage more people in this process, we certainly hope that they are learning from these videos before they get so deeply entrenched. And remember, again, once this training is over, all the trainings are downloaded and put up on a YouTube channel, Family Forward. The audios are downloaded and uploaded to my Spotify account that's under my name, Connie Regularly. The Family Forward Project on Facebook is where we list the events and put the Zoom links for the Friday afternoon trainings, and we'll soon be adding our other participation events there. I really appreciate people participating. I appreciate you blocking off some time on Friday afternoon, even though we're not engaging interactively, because I want to make sure we cover this topic in a reasonable time. It certainly helps me to keep the energy up and watch some of you I know and know some of your stories, and I can direct some of those questions and statements even before you ask the question on some of these particular topics. So y'all are great. Hang in there. We have much work to do. We have training number 5 under our belt now, and we will stop recording, go offline.